Welcome, I'm Todd King with the Accident Recovery Team. Welcome to the Accident Recovery Team podcast. With me is one of my partners, Gary Albin. Say hello, Gary.
Hello, Gary. Sorry, wait a minute.
Now, you previously, those of you that have been listening, have been listening to a series we've done on personal injury, in particular motor vehicle accidents. And that was with Sean Brennan, our other partner.
Correct.
The man with the head for business and the voice for radio.
Oh, that's right.
I apologize in advance. I don't have that booming voice, but we're going to cover a different topic, Gary and I, and that is workers' compensation, industrial accidents, and work comp for injuries that occur in the state of Kansas anyway. There are a lot of differences between this and personal injury, a ton.
Oh, absolutely. Work comp primarily is what's called an administrative system, meaning each state's laws can be a little bit different because they're all created by the legislatures. And so there's certain benefits to that where you can get, as an injured worker, certain types of benefits quicker than if you're in the regular tort system, like for a personal injury claim, but then there's a trade-off. There's also some benefits that you don't have in the works comp, so it's important to kind of know the difference.
And this is, for people to understand, anybody listening, I'm not going to spend a lot of boring history here, but to give you a background, the Kansas work comp system came out in 1911. It was one of the earliest ones in the United States. But to understand why the work comp system exists, you kind of have to understand what it was like without it.
Right.
And if somebody got hurt at work or an industrial accident, they didn't have the same access to the evidence. They were typically fighting an employer, a large company. It wasn't an even playing field.
That's right.
And so the quid pro quo became, this statutory animal that created a playing field where you're not going to win enough money to put anybody out of business, most likely, but they created an environment where if you got hurt and had a claim, you were going to get something. You were going to get treatment, you're going to get some settlement, but no one gets pushed out of the system and no one goes out of business because of the system.
That's exactly right. And you don't have to worry if you're the injured worker. You don't have to get into the whole issue of, was the employer negligent? Did they do something that caused my accident? I think one of the most significant differences between work comp and like a personal injury claim is work comp is no fault, in the sense that if you can show that you were injured at work, and there are some exceptions, but by and large,
which we'll get into.
Exactly. But by and large, you were not horsing around. You weren't ignoring safety devices or procedures that the employer had implemented. Even in theory, if the employee was at fault themselves, doesn't matter. It's covered under work comp, and you're exactly right. You don't have to wait to get medical treatment. The idea is you get medical treatment much quicker. You don't have to wait to get paid if you're off work. When I say you don't have to wait, there are some delays, unfortunately, under the work comp system, but by and large, it works much more quickly to provide medical care, to provide money to tide somebody over while they're healing before they can get back to work. And then, as you say, there's a settlement. There's compensation for the injury sustained itself under the work comp system within certain guidelines and a framework.
Now, personal injury claims, like motor vehicle accidents that Sean's been talking about for the past several weeks, that kind of law is fairly well established. It's been established for quite a while.
Sure.
One of the differences when you're dealing with work comp is that it's a system that can change frequently. As long as the legislature is in session in Topeka, for example, in our capital, the law can be changed on any given year. The statute can be tweaked, amended, and all of a sudden we're dealing with some new rules.
Absolutely, and there could even be changes that come about as a result of the Kansas Court of Appeals or the Kansas Supreme Court saying, maybe this is how this law has been interpreted in the past, but this is how it should be interpreted now. So it's a fluid system. Things can and do change, and that's probably why it's so important not to make assumptions, not to take advice, I would suggest, from well-intentioned coworkers or somebody else. Going to talk to an experienced work comp lawyer that's up to speed on what the current status of the law is and knows what rights you're entitled to and what obligations you have as far as giving notice. It's critically important.
Because how many times have we heard, my uncle had a case and it was like this. Well,
Right.
your uncle's case was out of Texas, number one. Or your uncle's case was from 1983 or something that would explain that it was an entirely different law, an entirely different system than what we're dealing with now. For the benefit of those listening and looking back to this, we are in August of 2020, the nightmare year of 2020, right? So everything that you and I are going to talk about over this series of podcasts would involve the law as it's written currently.
That's correct.
So,
right.
We'll start with the fact that when someone says work comp, there are people that will call us for consultation. Of course, consultations are always free at our office, so we'll talk to anybody that has questions. But they'll call up, and many times I'll detect that they're confused about what this entity is when they say work comp.
Right.
And so let's break that down. First of all, there's the work comp statute, the legislative creation written on the books. So you and I might refer to a work comp law or a work comp judge, or we're referring to the statutory animal or the administrative process. The employer, however, probably wouldn't use that term that way. They would be referring to their insurance.
Right.
The statute would require, and we'll get into the specifics here in a second, but in short, the statute, the Kansas statute, would require certain employers to go out and procure work comp insurance to cover what's mandated by the statute. And so the employer would refer to work comp most likely as the agency, the insurance agency, or that coverage. Fair
Sure.
enough?
Absolutely. See that all the time.
And so explain to folks the difference between a claim and a case, because that's something else that confuses people.
Sure.
You know, they'll say, I already have a work comp case. And then in the course of the consultation, we'll detect that, no, you really don't. What you have is a claim that's floating out there with an insurance company. It's not a case. What's the difference?
No, that's exactly right. Once a person gets hurt, first of all, once a person gets hurt, they have an obligation to provide at least verbal notice to the employer within 20 days of the fact that they got hurt at work. If there's a little bit of a twist to that, though, if a person ends up leaving their job before that 20 days is over.
As in ending the employment.
And then ending the employment, they retire, they resign, they're terminated. The statute says you only have 10 days from your last day of work to go ahead and give notice. So the most important thing is you want to give notice, I would suggest, almost always, and there can be exceptions, but almost always, if you got hurt at work, you should let your supervisor know. That keys some responsibilities on the employer to provide a written notice, but even if they don't do that, if they drop the ball.
And their obligation, when you say their written notice, that is reporting to the state
Right.
within 28 days of them having received notice that you got hurt.
But that starts there being a claim, but in order to have a case, in order to go ahead and make sure your case is docketed with the Kansas Department of Labor, which is the state agency that oversees all of this stuff, beyond giving verbal notice to the employer within 20 days or 10 days if you're no longer working there, you have 3 years from the date of the injury to provide written notice or I guess now it's probably electronic notice because most of this stuff is done through a computer system. But you have 3 years, regardless of what the employer has done, to give a written notice in the form of what's called an application for hearing with the Kansas Department of Labor. I've had people call in and say, I got hurt a year ago. I told my employer right away, that this happened. They provided, the insurance company adjuster called me, provided some treatment, but I never really got better. I've even asked for more treatment. They haven't done it, or I've just been working. And I called up the insurance company adjuster and said, I want to go back to the doctor. And they said, I'm sorry, we already closed your case. Well, they haven't closed anything. They maybe have an electronic file at the insurance company saying, this is what's associated with this risk, but they can't close your case. If you still have that 3 years to file the case with the Department of Labor where it's docketed, and it gives you the right, if there's a disagreement regarding medical treatment or benefits,
As we've always said, don't let your employer or the insurance company tell you what your rights are. Don't let them tell you don't have a case. Don't let them tell you that they've closed your case.
Absolutely right. They have a little bit, there's two ways to look at it. They might have your best interests of heart, but they might be wrong. Or maybe they're trying to, maybe they don't necessarily have your best interests at heart. But
So, in short, a claim would be that your employer has turned it into their insurance.
right,
A case would mean that you're not satisfied with what's happening at that level, and you've notified and done the proper filing with the Department of Labor, Division of Work Comp out of our state capital, and it is now docketed, a judge is assigned, and you can take your grievances there.
that's exactly right. And it's set up so that an injured worker doesn't have to have an attorney in theory, and they can file that claim, or that case, I should say, with the Department of Labor themselves. I would say the vast majority of people don't do that, though. They have a question, they want to know what the rights are, they contact a work comp lawyer, whether it's you or I or one of our competitors. The vast majority of cases are filed by the attorney on behalf of their client in order to be able to get in front of a judge and either get more evaluation, more treatment, or more benefits.
By the way, we're going to, over the next series, we're going to dive into some of these details. We're going to have an entire podcast dedicated to how to get, maintain, and address changes in treatment.
Pretty exciting stuff.
Yeah, exactly. We're going to go over the procedural requirements going through the legal process. We're going to dive into all of that. So what we're talking about today is an overview, right? Fair enough?
Exactly.
And I wanted to mention when I introduced you, Gary, and I forgot, just so people listening understand your sage wisdom and where it's coming from. How long have you been practicing?
Well, I was admitted to the bar in 1990, so yeah, I'm coming up on 30 years. Now, not all of that has been solely in the work comp area, but yeah, I've been going at it, good golly, 30 years.
And as much as you and I have been at this, and as much as I would like to say that we've, have a vast knowledge of this stuff, I would reiterate, this stuff changes all the time.
Absolutely.
Right? And it's a matter of perpetually learning and staying on top of it. It's not just you acquire the knowledge and can then apply it. You have to continue to learn because these things change.
Well, now, wait a minute, just a second. You've told everybody basically how old I am. Turnaround's fair play. How long have you been at this, Todd?
Not quite as long as you.
But a long time.
All right, so we understand now there's claims to be made. There's a way to make a case, right? So under work comp then, now some employers, some employment relationships are covered by the statute, some are not.
That's correct.
So if you've been injured in the course of work, really the question becomes, were you injured in the course of an activity that's covered, jurisdictionally speaking, by the work comp statute vis-a-vis the employment relationship, right? So
Right.
the threshold is what, $20,000 in annual aggregate payroll for the year preceding the accident.
That's right, meaning that if you work for an employer and their annual average payroll to employees is less than $20,000, that's actually outside of the work comp system. There may be other remedies you could pursue, but right, that's not technically covered under work comp. Also, if you're an independent contractor as opposed to an employee, that's a big distinction. And that there's cases that talk about what's the difference between an independent contractor versus an employee. There's a lot of different nuances. Again, I would strongly urge people, don't rely on your employer saying you're an independent contractor, not an employee. Don't even rely on a piece of paper that maybe you signed that says, I'm an independent contractor, not an employee.
Or even if you think you're an independent contractor.
That's right. The court says it's not what people call themselves, it's what is actually where the rubber meets the road. How are you treated? Does this person have the right to set your hours? Do they provide the tools? Do they have the right to hire and fire you? Bottom line is go to a lawyer.
And by the way, those are only, there's no bright line analysis.
Absolutely.
The things you just mentioned are only three
Of like 9 different
innumerable number of factors that the court looks at to determine whether someone's an employee or a contractor. And that's independent of what the parties themselves are calling themselves.
Right. So to be clear, an employee, as opposed to an independent contractor, is covered by the work comp system if their employer has an annual payroll of greater than $20,000, and if it's not an agricultural pursuit that you're engaged in. In other words, people that are engaged in what are called agricultural pursuits are not covered by the Kansas Work Compact, believe it or not.
Right.
Again, it's not always what you may think it is. There are
The definition of agricultural pursuit has been somewhat veiled and gray over the years as well.
Absolutely right. Bottom line is, don't make assumptions. Don't rely on what somebody else says. Go talk to a lawyer. Ultimately, everybody has the right to go in front of an administrative judge to lay out the facts, and that judge will make a determination based on what is going on in your particular instance, your particular case.
Even if you don't think you're covered, even if your employer doesn't think you're covered, you might still be covered, and a free consultation is well worth your time to come in and find out for sure.
Yeah, plus, the thing I always stress to people is that's 100% confidential. You go in and you talk to somebody for an hour, you don't get charged anything, and nobody knows you even talked about it. Then after you have some knowledge about what your situation is, then it's up to you as the person as to whether, do I want to bring a claim? Do I want to hire a lawyer to help me bring the claim? The point is that you have a right to make a educated, well-supported decision. And
I would add, just because maybe you think it's not a work comp case, and maybe it's not a work comp case.
Sure.
That consultation, as you and I both know, in the past has led to a discussion that, you don't have a work comp case. But guess what? You might very well have a personal injury claim against that employment entity or some other entity.
All right.
So you might still have a different kind of claim to be made.
That's exactly right.
So let's assume for a minute, we're going to bypass today borrowed servant and some of those other employment issues that could pull somebody that would otherwise not be within the jurisdiction of the employment relationship and might pull them in. That gets a little confusing maybe for people listening. We'll bypass that for the moment. Let's talk about an injury where the employment relationship does exist. We're within the jurisdiction of the statute, right?
Okay.
It used to be, there's been some legislative changes that have caused some havoc in the work comp system the last few years, but it used to be as simple as arising out of and in the course of your employment.
Right.
Two separate factors, right?
Correct.
What's the distinction between those two for folks?
Something arises in the course of employment if basically it happens on the job while you are, or on the, well, again, it all depends, but let's say you work in a factory setting. It arises in the course of employment if it happens while you're on the premises of the employer, generally during working hours. Again, there can be lots of little nuances to that, but that's, I think, in essence, a fair way to summarize in the course of employment. Now, if a person is driving to and from work, and it's, let's say they get hurt in a car accident on the way to work or coming home from work, you have to look as to whether or not travel is an integral part of the employment that you do. So in other words, a person who travels and makes sales calls on people outside, they're probably going to be covered under a car accident. Whereas when I leave my house in the morning to drive into work, even though travel is a part of what I do, generally I'm not considered to have arrived at work until I hit the front door, and I'm on the premises that are under the exclusive control of the employer.
Right.
But arising out of the course of employment means that basically you were engaged in an activity that you were hired to do. So if you're working a lathe, if you get injured while you're working the lathe, that's an easy case. If you were normally working a lathe, but they're doing job sharing, they want people to learn what's going on in the office, you probably still would be covered there. But if
I have probably oversimplified this in the past, but for the sake of the listeners, I've always said arising out of and in the course of, the shortened version would be it happened because of work and while you were at work.
Well, that summarizes in about 5 seconds what it was taking me 5 minutes to dance around, but that's a good way to put it.
And as you mentioned, though, there are a ton of exceptions, and some of those exceptions are statutory, some of those exceptions are case law. Mm-hmm. We've learned over the years it's not that simple. There's a ton of case law that talks about what kind of travel would be included in that and what wouldn't.
Sure.
As you point out, typically just getting to work is not part of the job.
Right.
But if there's something inherent to your work that causes you to travel, that kind of travel would be.
Mm-hmm.
Yeah.
No, that's right. And, and sometimes that arising out of employment if somebody's horsing around or not really doing what they're supposed to be doing, that may or may not be covered. If you get into a fight with the guy next to you and you get injured, happened at work, so it arose in the course of employment. Did it arise out of employment? Well, unless you're employed as an MMA fighter, maybe not. But again,
maybe not.
It's worth
There
going.
have been some cases where if the point of contention that led to the argument and ultimately the physical confrontation was work-related, those cases have made it past the judge in the past a few times. If it's an imported issue into the work environment where somebody found out about their girlfriend happens to be his girlfriend, well, that's an issue that was imported into the work environment, and the fact that it happened at work is irrelevant.
Yeah. If my wife is listening to this, she's probably thinking, I know Gary is such a nerd. He's sitting here, looking at all these little things, and you can't tell in the podcast, but Todd and I are both grinning. It's kind of neat to get into the facts of some of this stuff and trying to make a case and trying to make an argument on all this stuff. So yeah, it's not always what it appears at first glance. You've got to look at all the circumstances. It maybe matters why you got in a fight with somebody.
Well, and I know the reason you're grinning is the same as mine, which is every topic we touch on, I can think of a case specifically on that point.
Sure.
Something about it that makes me chuckle a little bit. So, prevailing factor is the new statutory addition to this arising out of and in the course of.
Right.
The new law added this.
Yeah, new law. That was 2011. So, but
that tells you how long we've been at this. That's still new to us, right?
Right, but that was
relative to everything before.
That was a huge change. It really shaped a lot. There were a bunch of changes that were implemented around 2011, which was, I think, about the advent of a certain governor who's no longer governor taking possession of the governor's mansion in Topeka. But yeah, we're still
totally irrelevant. Stay out of the politics.
I know. Okay, but the point is, that was a big change, and yeah, prevailing factor is a huge issue. That again, don't assume it's not always what you may think it is.
Right. The prevailing factor among all known factors as to why you're injured and need treatment.
That's right.
And ultimately what compensation you might get for
Maybe
it.
we could give an example. Let's say I'm a 55-year-old person who had some back problems in the past.
Are we pretending? Or?
Yeah, okay. Well, we're assuming a guy named
so.
Greg, okay? Not Gary, but Greg.
Sure.
And Greg maybe had back problems in the past, but in the course of working, he goes over and he picks up a 25-pound box of materials and feels a pop in his back. Oh, now I've got problems. He reports it to his supervisors. He's supposed to do. Now the question is, why are you having this pain? Or the legal question as to whether it's going to be covered under work comp. And it comes down to, it's a legal question that honestly seems to be driven by medical testimony and medical opinions. But the issue is, why are you having this discomfort, this pain now? Why do you need treatment now? If you have impairment, what caused the impairment? Is it lifting this 25-pound box at work? Or is that a factor, but it's also a factor that you had prior back problems before, and you'd had maybe degeneration just from years of hard work.
Well, and contrary, I'll just say it, contrary to common sense, the statute is even worse than that.
Yeah.
When it talks about pre-existing conditions. It's punitive almost on how they treat people. The statute actually says if it's an aggravation of a pre-existing condition, even if the pre-existing condition was asymptomatic, you could be barred from making the claim. What that means, folks, is that maybe you didn't even know you had it.
You weren't going to the doctor?
You didn't need any
problems?
treatment. You didn't need to see the doctor. You had no restrictions on you, no impairment whatsoever. But you had a condition you were unaware of, undiagnosed. The way the statute is written, you could still have that as a pre-existing factor that is weighed against other factors. And you may very well end up with a doctor retained by an insurance company who might say that factor is more prevalent, more important than the fact that you were lifting the box. And to a lot of people, a lot of clients that I've had to explain this to, they're looking at me like, that doesn't even make any sense. And it doesn't, in my opinion. But that's why we have other options to get other medical opinions. It's why we have judges that can look at this and say, yeah, that doesn't make sense. But the way it's written, you and I both know the insurance company doctors have used that multiple times, many, many times since the change in the law to deny a claim.
Oh, absolutely. I was thinking back on the podcast that our partner Sean did a little bit earlier, where he was talking about if you take your car into a body shop that's been selected by the insurance company, maybe you're not going to get as good a job done in repairing that car as if you go to an independent doctor, because that body shop perhaps has a relationship with the insurance company. They want to keep referrals being made to them. It's kind of the same thing. I mean, I'm not trying to impugn the doctors, but if
no,
you go,
you're not throwing rocks at the doctor's skill. What you're talking about are the blinders or the reins that the doctors or have on them from the insurance company.
I think that's right. That's they're not evil people. They're not trying to screw folks. But the fact of the matter is,
well, most of them.
Right.
Or not. Most are not.
But the fact of the matter is, if one doctor has their honestly held opinion that I don't think works the prevailing factor, you as the injured worker have the right to go get a second opinion. It's not an unlimited right. We'll get into that in a second. But most of the time, what really makes sense is to go to a work comp attorney who knows the doctors or their proclivities. Are they more employer oriented or more employee oriented? And and it's not just us.
You can make some pretty safe assumptions that if the employer and insurance company sent you there, there's a reason.
Right.
They are familiar with that doctor. He is used to being paid by them.
But you have a right to go to a different doctor, get a different opinion. You want to get an opinion. Again, part of the reason why it makes sense to go to a lawyer is to go to a lawyer can send you to a doctor that the judges are familiar with, who has credibility in front of the judges, and they may say, yeah, that first doctor's right, in which case you got the benefit under the work comp. One of the benefits that you're provided under the Work Comp Act, it hasn't cost you anything if you do it within the unauthorized medical provision. But let's say that doctor says, no, I disagree. You weren't having these problems before. I see a change in the physical structure of your body through an MRI or through physical testing. And they say, yeah, I think work is the prevailing factor. Now you've got a legal issue that allows you to go to a judge.
Good point. The provision that I cited and almost quoted, I think, that aggravation of a pre-existing condition is not a claim. That's a good point. There's a sub-provision to that, which I'm almost quoting but not quite, which essentially says, as you stated, unless there's a structural change.
Right.
Well, the problem for many folks is if they were undiagnosed and asymptomatic, they don't have any prior MRIs or anything to compare it to. So that structural change can be hard to prove or hard to diagnose that way. But you're right. If we can prove a structural change has occurred, we bypass that argument.
Sure.
Now, you bring up a good point. We've already established now there's a difference between a claim and a case. We talked about what kind of employment brings you within jurisdiction. We talked about arising out of and in the course of and the prevailing factor thresholds to make it a work comp case. So what benefits then, and again, we're going to dive into each of these things separately later. This is an overview. What benefits then can we expect to see in a work comp case?
Right.
So you've given notice, accident reports. By the way, you mentioned verbal notice is acceptable under the statute.
That's right.
I'm going to interject there and say, yes, that's true, but proving it's harder. Written notice is better.
Oh, yeah, without a doubt.
And
right.
accident reports, demand to fill one out, ask to see a doctor, all those things are better and easily proven if it's in writing.
For sure.
Okay, so what benefits can we expect? The first foremost is typically people wanting treatment.
Exactly. Medical attention. I mean, it seems to me, in very, very broad terms, there's three benefits. Medical treatment, temporary benefits, which are monetary benefits to compensate you for lost income while you're healing. And then once you're through with treatment, you've reached what's called maximum medical improvement. There's an assessment made for what's called permanent benefits, which are benefits for the injury sustained itself. But yeah, and that's part of why the work comp system is put in. Again, the idea is you get medical treatment much more quickly. You don't have to argue about who's at fault. You don't have to incur the cost of getting medical treatment yourself and then ask to be reimbursed, which is what happens like in a car accident case, where you have to take the costs on yourself.
You have to incur the damage.
You have to incur the damage and then try to get reimbursed if you can show the other party caused it.
Right. We don't have to do that here.
Right.
If you've been hurt at work, you've given notice, you can make that request for treatment. There's no co-pays, there's no deductibles.
As long as it's authorized treatment.
Right. When you tell your employer, I want to see a doctor, and they send you to the doctor, you shouldn't be hesitating on asking for that treatment under some fear that you're going to have a copay or deductible. You're not. If your employer sends you there, it's covered by work comp, you don't have a copay or deductible. Not only that, once the insurance makes their payment on the bill, there's a specific statutory provision that says the medical provider cannot bill you for the remaining balance.
Correct. That's right.
So you want to ask for that treatment. You don't want to be shy about that.
Best case scenario is they provide it timely. If they don't, I would say don't wait on them. The system moves as fast as you can push it. And
Yep.
by pushing it, I mean go in and talk to a lawyer, get the paperwork filed. Because authorized medical care, you're right, it's care that either the insurance company and the employer voluntarily provide or that a judge orders them to provide. So if they aren't stepping up to the plate and doing right to begin with,
Get in front of a judge.
yes, exactly.
So treatment, and we can get second opinions about maybe there's a body part they're not addressing, maybe there's a complaint they're not addressing, maybe your treating doctor has recommended treatment or some testing that the insurance company is not authorizing. All of those things we can address with a second opinion, we can address with a preliminary hearing in front of a judge. So there's the treatment, what I call the treatment phase of the case, right?
But one thing you generally don't want to just go ahead and get treatment on your own because that's not considered authorized treatment. That's unauthorized treatment.
And you can get stuck with the bill.
Exactly right. Under the statute, the employer only has to pay $500 of unauthorized care. So if you go get an MRI from your own doctor without getting it pre-approved or court-ordered, if it's a $1,500 bill, you might get stuck paying $1,000 after the employer pays their statutory max of $500. And that's bad. And you can avoid that by getting it authorized.
Truth of the matter is, come see us. We can better spend that unauthorized medical than they can.
That's
because we can get you
true.
to an expert.
Yes.
You mentioned the off-work benefit, TTD and TPD.
Right.
Total and temporary partial disability benefits.
Right.
The short version is that if the doctor takes you off work, or the doctor gives you a set of restrictions that your employer cannot or will not accommodate, and you are off work, you would be paid 2/3 of what was your pre-injury gross average weekly wage, subject to a cap.
Right. And that's after you've been off work a week. There's a 1 week waiting period, meaning if you're only off work 4 days, in theory, under the law, an employer doesn't have to compensate for that. But beginning with the second week off work, you're right, that temporary, the compensation rate, the temporary total disability rate is 2/3 of your pre-injury wage, meaning they'll look at the 26 weeks of earnings you had prior to the date of your injury. It should include overpay, if there's shift differentials, even if there's bonuses, you can go back, I think, a year to look at bonuses. So you want to maximize that because not only will that affect the amount of money you're getting while you're healing, it also factors into the equation that shows how much money you get for the injury itself. The higher the rate, the better you do.
We kind of talked about these quid pro quo exchanges for not having to prove fault in a PI system. One of the caps, the first cap a person might run into is there's a cap on the weekly benefit that you can get.
Right.
What is it currently? $687 or something like that right now.
I believe that's right. I was trying to think before I came in here. My little cheat sheet only goes to the end of 2019. It was 645 then, but I think you're right. I think it's like 680 something.
Yeah. Now, temporary partial disability benefit would be a doctor giving you a restriction, you return back to work, and the employer either puts you in a position at fewer hours or puts you in a position that's at a different rate of pay. You've lost some money, but not all your money, and the work comp comes in and pays 2/3 the loss difference.
Right. And I guess I should finish the thought about there being the 1 week waiting period. Your benefits start with the second week. But if you're off work 3 weeks or more, then that first week waiting period drops that out. And now they would be responsible for paying TTD or TPD during the entire period you've been off work. But again, it's off work under doctor's restrictions. So just saying,
it's not because you don't feel good and you're in pain and want to go home. That would not be covered.
Well, not unless you can get the doctor to kind of document it or get the employer to sign off on that. And then when you send it to the insurance company, now all of a sudden it's the insurance company paying the benefits, and they're probably going to talk to the employer and say, "What are you doing? Why can't you accommodate this person?" But
so treatment, that's a benefit you can get. An off-work benefit during the course of treatment up to the point, as you say, maximum medical improvement, which people fundamentally need to understand. because we're going to talk about treatment later in a different podcast, but you have to fundamentally understand when you start a work comp case, not every injury can be fixed.
That's 100% right.
And sometimes it's the doctor kind of throwing his hands in the air and saying, this is as good as I can do. I can't make you any better than this. And at that point, and I'm going to ignore for a minute maintenance care and some of those other things, the doctor can essentially say, I'm done treating you. And the insurance company in kind can say, then we're done treating you and we're done paying you. Now, many times that's when people come see us. Some people
Sure.
come see us right after they got hurt. Some people come see us the minute there's a hiccup in their treatment, or they're not getting paid for the off work benefit. Or some people come to us when treatment, the door has been slammed in their face, and that's when they come see us. Then there's, like you point out, at the maximum medical improvement stage, there's an assessment done as to what loss of function the body might have. There's compensation that can be paid for that. There's another category called work disability.
Right. Well, if you don't mind, I might just add, because
Sure.
one thing you were mentioning about that maximum medical improvement, just like different doctors will have different opinions as to what's the prevailing factor, different doctors will have different opinions as to when you've reached maximum medical improvement.
Absolutely.
So you're exactly right. Let's say you've reported an injury, you've received authorized treatment voluntarily from the employer, they send you to somebody, doctor says after a few weeks of physical therapy, I think we've done all we can do. And then, but people will say, legitimately so, I'm still hurting. You have a right to get a second opinion from another doctor
The
there.
legitimate concern there is that those doctors who are being paid by the insurance company have this voice in their ear saying, geez, we've been treating this guy for 4 months, 5 months. Can't we cut him loose? You need to cut him loose. Hey, we want you to cut him loose. Like they're getting that in their ear from the person that's paying the bills.
Or maybe even a nurse case manager. They may literally have, because an insurance company has a right to assign what's called a nurse case manager, somebody to kind of monitor what's going on. They have a right to do that. You have a right as an injured worker to say, well, I don't know if I want a nurse case manager or not, but by and large, a nurse case manager isn't necessarily a bad thing. But they can go to the appointments, they can schedule appointments, they can facilitate you getting prescriptions. What they're really not supposed to do is go into the exam room when you're in there with the doctor getting treatment and evaluation. And I know you and I both have had so many people report back saying the doctor was going to say, let's do some more treatment, and the nurse case manager talks them out of it. Says, what good is it going to do? Let's stop it.
I need an MRI. Can't we do an X-ray instead?
Sure, because that's less expensive.
I want 6 more weeks of PT for this patient. How about 3? Yeah, we hear this all the time.
It's not supposed to be a negotiation, right? The doctor, and I think most doctors by and large do. I mean, I think their heart's in the right place, and they're exercising independent medical judgment to the extent they can. But they also, the insurance company doctors, so to speak, want to keep those referrals coming in.
And just like doctors can disagree about prevailing factor, just like they can disagree about when MMI has been achieved, they can disagree as to what that final rating is.
Oh, for sure.
Which there's a formula, folks. We're not going to go into this, but there's a mathematical formula for how that impairment rating equates in a monetary compensation.
Right.
There's no pain and suffering in work comp. It all stems from this functional loss. The statute requires the doctor give a rating under the AMA Guides to the Evaluation of Permanent Impairment. Presently, the statute says 6th edition. Whether or not the 6th edition is constitutional is currently pending before the Supreme Court. We'll find out eventually one day whether we go back to the 4th edition or whether it'll be the 6th, but presently it's the 6th. The problem is, even though the statute says use this book, when you open the book and read it and understand it, there's more than one method to use to rate somebody. Insurance company doctors tend to use one method, which produces a lower number. Other doctors, those that we have sought out and found, tend to use another method which produces a higher number. The judge knows that both of those are acceptable methods, which means in the judge's eyes, we're probably looking at a value somewhere in between.
Right. The truth lies in the middle, perhaps.
Most of the time.
Right.
We'll dive into that more further because later on we're going to talk about court neutral examiners and things like that. But there's, just in concept, understand at this point that there's compensation that'll be owed to you if you've been injured. Then there's the potential for economic damages if your injury affects your ability to return to work. That's called a work disability. we have to hire a vocational expert to address that, and I'm happy to report that a vocational expert here in town is going to come in and speak with us for that.
Right.
So for that podcast, we're going to enjoy the benefit of a guest.
Right.
So,
And I might just add as an aside, not every injury necessarily is subject to the work disability analysis. You have to have the right type of injury, and by that I mean an injury that's considered to be
There's
to your
some
body as a
threshold,
whole,
yeah,
right?
yeah.
And you have to have more than a certain amount of impairment.
and we will get into all of that, but yes, there's some threshold elements to make that difference. Another category of damages is perm total.
Sure.
A work disability would be a finding that you can't return to the job you were doing. In short, a permanent total disability finding would be that you can't return to any gainful employment of any kind. And finally, of course, in the statute, there is a statute dealing with a death benefit if the injury amounts to that, which unfortunately we've also dealt with. So we've got a lot to cover in the coming weeks on all of this stuff. As you're about to resolve a case, let's say you've been through the system, you've accounted for your damages, the system would require then that you have what's called a regular hearing. I have an existing client, actually, no names shall be used, that is thoroughly confused by this process, so it probably warrants clarification here. A trial in the work comp system is not the same as a trial that you would have under a motor vehicle accident claim, for example.
Right.
So procedurally, you would appear at what's called the regular hearing, and if you are the injured party, this is your opportunity to testify. It's your day in court. It's for the judge to assess your credibility and your testimony.
Right, and that's important that it's the judge doing that. You don't have a right to a jury trial in the work comp system. So it's not where there's going to be 6 other or 12 other people assessing this. It's more informal in a sense where normally the judges don't wear robes, although some do. But it's a judge hearing testimony, generally testimony from the claimant themselves, the injured worker themselves. But a lot of other testimony will come in later, or perhaps earlier, through what are called depositions. So the doctors don't come in.
That's what I was going to get at.
Right.
And the confusion that one of our clients has, and I want these folks to understand, at that hearing, sometimes there are other witnesses, but typically the injured party is testifying. The judge then imposed what are called terminal dates. Mm-hmm. He imposes 30 days for us to finish submitting evidence. Doctors do not want to come to work comp court and spend their afternoon waiting their turn to sit down and testify about their report.
And to be perfectly honest, we don't want them billing us for the time they sit waiting in the waiting room. So
doctors' testimony typically comes in by way of a deposition transcript, which is taken during that 30-day evidentiary window following the regular hearing.
And the clients aren't there, the judge isn't there, but there's a transcript made by a court reporter that everybody can look at later.
30 days following that is the respondent side's evidentiary window for them to take their testimony, and then all the evidence is submitted to the judge, and the ultimate decision would be made from the judge. At any point during that process, even after the regular hearing, even after you've testified as the injured worker, settlement negotiations can be happening clear up until the day that the judge enters his decision.
Sure.
And so there are, and we're going to talk about it right now, we'll talk about it later, but there are some overlapping issues when you start looking at how to resolve a case. During the pendency of a work comp case, you can kind of focus on these issues that we've talked about and that we're going to talk about more. As you're starting to wind down a work comp case, however, we need to start looking at maybe there's an overlap with Medicare, maybe there's an overlap with Social Security disability, maybe there's been some short-term disability policies invoked that may need some addressing. But the point here, I think as we wrap this up, people need to understand work comp, even though the settlement or the award might be referred to as a permanent disability benefit, it is not a permanent benefit.
Right.
It's awarding you or agreeing in a settlement to pay you for a permanent injury. It's not a permanent benefit. It's a fixed amount of money for perhaps a fixed period of time. So it's a stopgap measure. Some people will need to then move on to some other system, and sometimes that might be Social Security disability, for example, or maybe they're old enough for the retirement benefit. But there's sometimes another system outside of work comp that we'd have to start looking at.
Sure.
Right. And so there might be an overlap of benefits we have to address. There might be settlements where closing out future medical versus the Medicare would require some expertise from an attorney for folks to get that figured out. We are going to dive off into everything we've just discussed in greater detail. I can only hope and pray that the rest of it is not as boring maybe for folks as it was today.
Maybe we'll get better at this with more practice we get. I don't know if we're as dynamic as Sean is.
Well, and Steve, what people don't understand is I'm such a geek that I like talking about this
I
stuff.
kind of do too.
And people can't see that as we're sitting here talking with smiles on our faces. But if you've been injured, please follow us through the rest of these podcasts over the coming weeks and months. I think this will be probably a 5-part podcast. Next time we're going to dive into, in detail, how to start medical treatment, how to get the treatment you need, how to get second opinions, and how those opinions ultimately bring you to a value for your injury. Our hope is that we can bring in one of our doctors or one of the doctors in town that participates in the work comp system. We have a lot of great doctors in Wichita, Kansas. Not all of them participate in the work comp system, however. So, but we have our feelers out there. I hope we have a guest on that. In the coming weeks, we'll get past the treatment. We'll start talking about damages. We'll start talking about litigation process and strategy. And then ultimately, we're going to talk about how to really wrap the case up and address all of those overlapping issues for the best interest for you, the injured worker. Finally, there is something in the work comp system referred to as future rights. It's the right for review and modification, the right maybe for additional medical treatment in the future. We will have some discussion on that because those are very important issues as well. When someone comes to see us, it's usually, I need treatment. The second issue becomes, I need compensation. And the third and big question for folks is, what about my future? So we will address that for you folks too. Right. I'm going to say goodbye.
I'd like to add, if somebody has been good enough to have bared with us during all of this so far, there's one thing I kind of want to stress, which is, do you legally have to have an attorney to represent you in a claim like this? No, the law doesn't require you to do it. But the insurance company and the employer have nurse case managers, adjusters, sometimes doctors, kind of helping protect their rights, I should say. As an injured worker, you've probably got a lot of anxiety, uncertainty, frustration, not to mention physical pain you're dealing with. It is time well spent to go in and talk to an attorney free. It doesn't cost anything. It doesn't obligate you to anything, but to know what your options is. It's easy if you've reported the case and they haven't provided treatment, you know you need to go into somebody right away. But if you have questions about, am I getting the right type of care? Are they addressing all of my injuries? Am I getting fairly compensated for this? You really need to probably talk with somebody who has some familiarity with the system, and you will not be sorry that you did.
And what we've talked about in terms of complexity is the tip of the iceberg.
Oh, yeah.
And not only that, the iceberg you're standing on, it's more of like shifting sands. It is fluid. These things change, and it's complicated. Yes, theoretically you could represent yourself, but in light of the environment that you're in, it's really a complicated thing to undertake on your own. Get that free consultation. It's confidential, like you say. And quite frankly, we're nice guys. It's not the hard sell.
Right.
Just come in and educate yourself. Like I say, with that, and we've got more episodes to come, and we'll dive into things in greater detail. But for today, I'm Todd King with the Accident Recovery Team. I'm done. I'm out. Gary?
Yeah, and I'm Gary Albin with Accident Recovery Team. We're at 833 North Waco in downtown Wichita. You can contact us if you have any questions at 267-TEAM or team. And I can sincerely tell you, I hope you don't need to talk to a work comp attorney. They stay safe and healthy. But if you do, if you have any questions at all, please feel free to give us a call.
Goodbye, everybody.
The lawyers of the Accident Recovery Team are licensed in Kansas and Kansas only. If you are unfortunate enough to live somewhere other than the great state of Kansas and have questions about an auto accident or an injury accident of any kind, you can still call the Accident Recovery Team and we can partner with an attorney in your state to help you get the representation you need. The Accident Recovery Team can be found at 267team.com or by calling 1-866-267-TEAM.